Class on legal. Her name is Ntombi Dube. I met Ntombi maybe 8 years ago now.
Yeah.
So I'll share a little secret. Ntombi is actually our lawyer in our group. So we use her all the time. And the team thought that, we should abuse her more. And instead of her giving us invoices for all the work that she does for us, legal services, she should also come here and give back to you her skills. So Ntombi's masterclass is called Beyond the Fine Print, How to Avoid Legal Pitfalls in Your Business. Ntombi brings over 16 years of experience. She's worked for some of the top law firms in South Africa until she started her own business. She specializes in commercial agreements, tax strategies, company law, contract law, I can tell you for sure, and also mergers and acquisitions. If you're trying to buy a business, or you're trying to sell a business, or you're trying to have a joint venture with a business, she's very, very good at that. So ladies and gentlemen, the managing director of Ntombi Dube Incorporated, please put your hands together for Ntombi Dube.
Thank you, my friend.
Do you need this mic?
I'm actually not sure.
Okay, let me just drop it for you so it doesn't bother you.
I was told that I sort of have to stick in this vicinity.
I suggest you listen to your lawyer.
Yeah. Welcome, everybody. Good morning. Thank you so much to FNB, I'm an entrepreneur, and to all of you for being here. I've been asked to talk to you about the pitfalls, particularly the legal pitfalls involved in running your own business. The way I intend to go about this, we're going to look at what I call regulatory compliance. Then we're going to look at some labor law issues. And finally, I'm going to give you the briefest how to understand contracts lesson that you'll ever have in your life. So shall we get going? They've allocated a little bit of time at the end for questions. And I don't know how much time I'm going to need. So can we please just maybe note down your questions, and at the end we can have a Q&A, yeah? Let's get going. Ish, as a girl from the township, they're giving me all these gadgets now. Let's see if I can figure it out. Okay, there we go. This is what we're talking about this morning. There we go. So this is the layout of today's presentation. We're going to look at regulatory compliance. We're going to look at labor law compliance. We're also going to look at contracts and understanding them, yeah? Let's set the scene. Most of us, when we start businesses, we all get the same advice. You can't run a business except if you're a company. There are many vehicles that you can use to run a business, but a company, a PTY Ltd, is the most popular and it's the most widely used. And that is what we're going to talk about today for that reason. So you go to SIPS, you register your company, you pick a name, they register it for you, they send you your registration docs, voila, you now have a company. What are your obligations in relation to that company, right? Where CIPC is concerned, your first obligation is to submit your annual returns. Your annual returns for SIPS are basically an annual return where you declare your turnover and you pay a fee based on your turnover, right? That's only once a year. And because you, as the owner of the business, are registered with SIPS, they'll send you an email reminder to say, next month, your annual return is due. Don't ignore that message, because if you do and you fail to submit your annual returns, what happens is, A, you start incurring a penalty for that, and B, the longer you stay without submitting them, they then start the deregistration process. You will see when you look at your company, when you search for it on SIPS, it will show, instead of saying in business, it's going to say in the process of deregistration, non-compliant. So that is why you need to stay on top of your annual returns. SIPS has come and introduced an additional requirement now, and that is the beneficial ownership declaration. So the beneficial ownership declaration is intended to assist the authorities in combating money laundering. So essentially what this declaration is meant to do, it's meant to allow SIPS and the authorities in the country to see behind the company. Because remember, when you have a company, the shareholders of a company can be anybody. It can be individuals, it can be trusts, it can be other companies, it can be partnerships, it can be anybody. But what this declaration is meant to do, it's meant to go behind the veil of the company to see who the actual individuals that control this company are. So now what has happened, and it started this year, is that before you can submit your annual return, it forces you to first complete this beneficial ownership declaration. And in there, you basically say who the shareholders are and what their shareholding is, right? And then the other thing you need to comply with where SIPS is concerned is the changes that affect the company. So anytime you want to change the company's registered address, you need to let SIPS know. Anytime a director is resigning, you need to let them know. A director is appointed, you need to let them know. If you want to change the name of the company, you can only do that through SIPS. Again, you need to let them know. If you want to change your memorandum of incorporation, remember the memorandum of incorporation is like the constitution of the company. It tells you how many shares the company can issue. It tells you how many directors the company is allowed to appoint. It tells you how the meetings are supposed to be run, how resolutions are meant to be passed. So whenever you want to make changes to the MOI, again, you need to let SIPS know, right? So you are now compliant. You've submitted everything. You are up to date. You are compliant. You are in business. But there is some housekeeping that you need to keep in mind in relation to your company. Remember, a company is not your personal thing. If you own a company, it means you own shares in the company, right? How do you prove that you own the company? How do you prove that you have shares in the company? You need a share register that says this company issued shares to Ntombi Dube, 10 shares for 10 Rand, right? And if those are the only shares that have been issued by the company, then it means automatically I am the sole shareholder because I own all 10 shares that have ever been issued by the company, right? And then, of course, if I get new shareholders, I want to partner with new people, and I give them shares, then it means I no longer own 100%, then I'll probably go down depending on how many shares I want to give them, right? So what has happened with the Companies Act is it allows you to have shares without having share certificates. Whereas under the old Companies Act, long before your time, I've looked around the room, long before your time, you had to have a share certificate as evidence of the fact that you're a shareholder, all right? I see you. I recognize you. Yes, yes. Not alone. So now the new company, I still call it the New Companies Act, and it's from 2008. You can tell I'm old. Now the Companies Act says you can have shares that are uncertificated, meaning that don't have share certificates allocated to them. So essentially, you can have a share register and share certificates, or you can just have a share register recording who the shareholder is. And the way you transact business in a company is through resolutions, right? So depending on how many directors you have in your company, if you're the sole director, then the rules are a bit more relaxed. You can basically do whatever you like, right? Because the Companies Act says if you're the sole shareholder and you're a director, a lot of the formalities that are provided for, you can skip. Because literally you are transacting with yourself, right? But if you have other shareholders and you have other directors, then the way to transact the company's business is through resolutions. You need to have board meetings if there's a lot of directors, at which the decisions that affect the company are made. And having made those decisions, they're either recorded in the minutes of the meeting or they are recorded in resolutions. For example, you would have a resolution that says, whereas the board of directors have decided to change the name of the company, the date, and everybody signs. And one of the things you require to be able to have SIPs change the name for you is such a resolution. They want proof that everybody that's involved in the company, that's in the leadership of the company, agrees and is happy to change the name. So that's it. Share register, share certificates. Without a share register and a share certificate, you can't claim to own the company. You are just like me. Yeah? Yeah. So I've spoken about resolutions. The other thing that you need to think about is what we call a shareholders agreement. Now, a shareholders agreement is meant to regulate the relationship between the shareholders, right? It tells you how the shareholders want to run the company, what they think is important, how they're going to make decisions. The shareholders agreement is a document between the company and its shareholders. It's not a public document. Unlike the MOI. The MOI is a public document. That's why you submit it to SIPs. Anybody can request your MOI and see what the rules that govern the company are, right? But a shareholders is just between the company and its shareholders, and you only really need one when you have more than one shareholder, right? And when you have more than one shareholder, and obviously you need to regulate, for example, let's say there's two shareholders and both of you own 50% of the company, right? One of the things you would have in your shareholders is a provision about how you break the deadlock. Because if you have 50 and they have 50, you can imagine when you vote, there'll be instances where it's deadlock and you can't reach a decision. So you would set out in your shareholders agreement how you break the deadlock. Whether A, you appoint an independent person to make the decision for you, or you try and conciliate and mediate or whatever it is to try and reach a decision. So that's the housekeeping. That's the stuff that you do to keep your business and your company healthy that doesn't necessarily get seen by SIPs or other people, members of the public, yeah? The other thing that you need to comply with for purposes of regulatory compliance is your professional body. It depends on the business that you're in. For example, as an attorney, my regulatory body is the LPC. And I need to pay subscriptions, I need to buy a license every year, we call it a fidelity fund certificate, those kinds of things. So depending on the business that you are in, the industry that you are in, you may have certain regulatory requirements that you need to comply with. And because you want your business healthy, you need to comply with those. Finally, as an entrepreneur, you will see how many times you will be asked for your BEE certificate or affidavit, all right? And I can bet money that in this room, there are entrepreneurs who are owners of companies who have done BEE certificates saying that they own 100% of the company, but have never issued a share certificate or have a share register. So I have met entrepreneurs that actually go on affidavit and say, I own 100%, but they don't because they have failed and missed the step of issuing shares to themselves to prove this ownership, yeah? So if at all, in any given day, you've submitted this affidavit and somebody says, please prove to me that you own this business, you're gonna be like, what do you mean? Because you don't have a share certificate or a share register. And that is why it is important to stay on top of those kinds of things. So that is regulatory compliance where companies are concerned. I'm going to move now and talk about the labor law issues. Yeah. So labor law compliance basically refers to complying with the labor laws of the country. I have my business, it is healthy, I've complied with SIPs, I've complied with the LPC, I am doing great, but I now realize that actually I need some help. I cannot do this on my own, right? I want to appoint people to help me, and I've decided that, you know what, maybe I'll hire one casual and one permanent employee, right? So I will hire an attorney junior than me to do some of the legal work, and I'll hire full-time an admin assistant. The labor laws say what I need to do in the process of appointing them and what my relationship with them is going to be. Yeah? So the first thing when you're thinking about hiring somebody or getting somebody involved in your business is you need to answer the question, do I need an employee, or is it okay if I get an independent contractor / service provider? The difference between an employee and a service and an independent contractor is the fact that an independent contractor works for many clients. They are not solely focused on one client. Right? Whereas as an employee, you are generally, even in your employment contract, required to only work for your employer and no one else. As an employee, you don't get to decide what time to rock up, how you're going to do your job, and you don't get to decide what you feel like doing. You get told what to do, you get supplied with tools, and economically, you are dependent on your job. Right? So now you've decided I'm going to go and appoint somebody as an employee. As I've said, I've decided I'm employing somebody permanent and somebody casual, right? The BCEA, which is the Basic Conditions of Employment Act, says when you employ somebody, you need to give them a written contract of employment. And not only does it say that, it also tells you what should be included in that employment contract. And over the next few slides, we're going to look at what is required to be in an employment contract. The obvious things need to be in that contract. And no, an oral employment contract is not valid. If you as an employer say, we've agreed you work for me now, and you don't put it in writing, you as the employer are contravening the Basic Conditions of Employment Act because it requires a written employment contract. The obvious stuff is in there. The name and the details of the employer, the name and the details of the employee, where this employee is going to work, the date on which they're supposed to start working, what hours they're going to work. And of course, you need to say what job they are employed to do. Be it a title, I personally advise that you not only give a title, but you also do a description of their duties. That avoids a lot of confusion and fights later on, because you can imagine where you say, I've appointed you as a cleaner, and you think, okay, that means I sweep and I dust and I'm done. And then I come and I say, no, but what about the windows? And you're like, but I can't do the window. I'm like, no, but you're a cleaner. You're supposed to do the windows. To avoid situations like that, when you employ somebody in their employment contract, try to be as detailed as you possibly can as to what their duties are. Remuneration must be included in the employment contract. Remuneration, how much are you going to pay them? Which day of the month are they going to get paid? And you also need to deal with whether or not there are going to be any deductions that you're going to make off their salary. Remember, tax is a statutory deduction. The employee can't escape it, you can't escape it. But there are other deductions that you and the employee may agree that you want to make, but you can only make those deductions with agreement with the employee. One of the deductions, a good example, is some employers run loan schemes for their employees where you can borrow small loans, like between 1,000 and 5,000 rand, if you have an emergency, a funeral, etc., etc. So then in this employment contract, you would say, if you ever use the employer loan scheme, then you are authorizing me as the employer to deduct your repayments of that loan as per this contract, yeah? The other thing you need to deal with in the employment contract is leave. Leave is mandatory under the Basic Conditions of Employment Act. It says that a full-time employee is entitled to 21 days of annual leave within a 12-month period. However, a casual employee, and casual is defined in the Act as somebody that works less than 24 hours in a month, they don't have an entitlement to annual leave. But they would have an entitlement to sick leave and to family responsibility leave and to maternity leave. But obviously, their entitlement is limited based on how much time they work. So they can't have the same 7 days as somebody that works full-time. They'd probably have maybe 2 or 3 days, for an example. Yeah? So you deal with that in your employment contract. Termination. This is provided for in the Act, and it helps to put it in the employment contract, where if the employee wants to leave, or you decide that for whatever reason, you need to let them go. This termination talks to a termination that is not caused because something has gone wrong. It is the employee has found a new job and they come and they say, I found a better job, better paying, closer to home. And this tells you how much notice they must give you. Similarly, if you're like, we've been at it for as long as we can, it's not working out, I would like to terminate your services. Again, we talk to these notice periods. If somebody has worked for less than 4 weeks, you give them 1 week's notice. If they worked for 4 weeks or more, then you give them 2 weeks' notice. If they've worked for more than a year, then they give you a month's notice, 4 weeks' notice. Yeah? Why do we even care, right? Again, we want to keep our businesses healthy. We want to keep them going. We want to avoid unnecessary pitfalls. And they are unnecessary because if you comply, then you have nothing to worry about. So what happens if you don't comply with the Basic Conditions of Employment Act? I don't know if you saw it. The one that comes to mind is Bubble Restaurant in Pretoria, where the labor inspectors came and there was all kinds of drama because some employees didn't have written employment contracts. The employer was not complying with the Basic Conditions of Employment Act. There were instances where employees were being made to pay for work equipment. Remember when I was talking about an employee being somebody who is controlled, who's given tools and they do the job? That's a requirement. As an employer, if you expect me to come and present and you want to earn from me presenting, then you need to give me the tools that will enable me to do the work. So the inspectors came and it was, snot and trane. Essentially, when you get to that point where the inspectors come, if they find contravention, they can issue fines, possibly even imprisonment. Yeah? And that is why compliance is so key. There's another piece of legislation that governs the labor relationship, and that's the Labor Relations Act. The Labor Relations Act deals with dismissals, the right to strike, picketing, etc., etc. So you look at this act whenever you want to dismiss somebody on they're not performing, they committing fraud, etc., etc. You look at the LRA and it tells you how to do a dismissal legally and properly. The other thing that you can look at is the HR policies. Now, a lot of us smaller businesses don't have HR policies. What that means is the Act applies. Because you have HR policies if you want to put things in there that are not included in the Act. But even in your HR policy, you cannot take away rights that have been given by the Act. So in your policy, you can give more rights. You can explain and set more detail, but you cannot suddenly say to people they need to work 12 hours a day. The PCA doesn't allow. So you have, even in your HR policy, you have to stay within what the legislation provides. Another reason why you want to comply is that employees have rights. So when an employee is unhappy and they realize that you are contravening the Act, they can first lay a grievance and say, let's talk, employer. You are treating me unfairly. This is what you're doing. And they have a right to be heard, right? Additionally, if you are seeing a problem and you think, but you're stealing from me, let's talk about it. I want to fire you. You can't just fire them. You have to have a hearing. And they have to get an opportunity to present their side before you can make a decision to dismiss them or not. And if you don't comply again, you run the risk of having to spend lots of money on lawyers' fees and lots of time, either at the CCMA or the Labour Court, fighting with your ex-employee who's now taking you to the CCMA because they're feeling that you treated them unfairly, you dismissed them unfairly, you don't have a fair policy on bonuses, those kinds of things. So that is compliance with the labor law in a nutshell. I'm moving on. There are other statutes that impact a business as it relates to labor law. And those are the Compensation for Occupational Injuries Diseases Act, that's HOIDA. This act is meant to cover workers from work-related either injuries or diseases. They can go claim. The OSHA Act, that is meant to cover workers in relation to safety in the workplace and safety in using equipment in the workplace. And UIF, that's the unemployment insurance. So when you have employees, in addition to your duty to deduct pay as you earn, you also have to contribute towards UIF. UIF, I think the contribution is 2% of the salary bill. And what happens with UIF is it is a form of insurance so that if an employee is retrenched or they are dismissed, they can go to the UIF and claim their unemployment benefits. So that's what that exists for. And that is labor in a nutshell. Now let's get to the interesting stuff, the stuff we really want to talk about. Contracts, how to understand them. Because as an entrepreneur, you've set up your business, you've got employees, you now need the clients or the customers. And in getting clients or customers, we always advise that whatever agreements you come to, you reduce them to writing, you sign a contract which sets out their obligations and their rights and your obligations and your rights. So what I'm going to go through this morning is a standard service level agreement. A service level agreement is an agreement in terms of which one entity renders services to another. So I use this because I can use my firm as an example in this to make it easier to understand and more practical. So in this service level agreement, Ntombi Dube Incorporated, NDI for short, is going to provide legal services to Vodacom. So I will use that as the scenario to take you through the various clauses in the contract, how you read them, how you understand them, and the sort of pitfalls that you need to look out for when reading a contract for understanding. The first thing is, it happens a lot to us entrepreneurs where when you're dealing with a much bigger organization, for example, a Ntombi Dube Incorporated dealing with a Vodacom, where I will say, but as an attorney, I've drafted this agreement. Can we sign this? And Vodacom's like, no, standard terms and conditions. This is what we make all our suppliers sign, and you need to sign it. In such an instance, if you are not comfortable, you need to get somebody like me to have a look at it. Because there is so much that is hidden in those standard terms and conditions. Because what happens a lot of the time with those standard terms and conditions is that they treat all their suppliers the same, from the smallest to the biggest. So what that means, for example, if Vodacom's policy payment terms are 90 days after invoice, it means you now, as a small business struggling to survive, are now stuck with payment terms of 90 days after invoice. And hence I say it is important to read, to understand, to read the contract and look at your business and how this contract fits in with your business and whether it's going to work, so that you do not commit to things that are going to trip you up later on. Let's go through the service level agreement. I have a declaration to make. My pointer. There we go. Let me see. I'm pointing. It's not clicking. Okay, I'm just going to go forward. Did I switch it off or something? Thank you. I didn't. Lovely. Can I use this minute just to get some water? So the declaration I was about to make is that the service level agreement that you're going to see on the screen is not one that I've drafted. So, and I did that deliberately because it's easier to critique somebody else's work than your own. I literally got it off the internet and I use it just as a basic agreement to talk through the relevant points. So when you're looking at an agreement, you have your cover page, you have your table of contents, you have a preamble or a background, and you have a description of the parties. Yes. So here's the service level agreement. The name of the agreement at the top, the parties that are entering into the agreement. Remember I said it is my firm entering into a service level agreement with Vodacom. So company would be Vodacom, their registration details, and you see where it says hereinafter referred to as. That is a definition. So we will then put there Vodacom, so that every time we use the name Vodacom, we don't have to say Vodacom Proprietary Limited with registration, blah, blah, blah. Because we've defined it in the front, that's the term we're going to use throughout the agreement. Service provider, NDI, our details, and note at the bottom it says, both hereinafter collectively referred to as the parties. So now you are going to see in the contract where the duties or the obligations refer to NDI, it will say NDI shall. Where the duties or obligations refer to Vodacom, it will say Vodacom shall. Where it is something for both of us to do as parties, it will say the parties shall. The other thing you need to note is, it's a thing that we as attorneys do. I think it's a relic from the past, but you will see that even though we've defined the parties, Vodacom and NDI here, you will see that even in the definition section, there's still another definition of the very same two parties. We do it, no one can explain why we do it, but we do. The other caution is, when you have an agreement like this, on the cover page, I avoid putting the registration numbers, because if I make a space to put the registration numbers and one of the parties is an individual, how do we identify individuals? By their ID number. You don't want this lying around somewhere with somebody's ID number on the cover. So I generally just put the full names and say herein after as, and that is why I will also have a fuller description in the definition section, where I do then put the ID numbers and the registration numbers. The table of contents, you really only need this when the agreement is very long. And you need it for purposes of trying to avoid having to read or go through the whole agreement when you really have a question about one thing. I want to know, I've signed this agreement with Vodacom, I want to cancel it. How do I do that? Then this tells me the page and I close and I go and I do that. I don't have to read the whole thing. The preamble or the background, it's also sometimes called the introduction, as they've done in this agreement. The importance of this is that it sets the stage. It gives the context as to why the parties are entering into this agreement. It is imperative to have this when you have more than one contract between the same parties. So for example, I have a previous agreement with Vodacom that ended last year in November. And now we want to extend or revive that agreement in this agreement. I would then put in the preamble that we had an agreement last year that terminated on this date. We want to revive it, and this is how we want to revive it, and the terms that are going to apply going forward. Yeah? Okay, more on the structure of contracts. We're now going to look at the definitions section. We're going to look at some specific clauses, and we're going to look at some standard clauses. The definition section. So the definition section in here operates like the definitions on the cover. It is meant to make it easy to refer to terms that are repeated a lot throughout the agreement. For example, because this is a service level agreement, you will define the services and you will say what they are. A lot of the times with a service level agreement, in defining the services, we usually refer to an annexure, and the annexure will have all the detail. So you don't have to put all the detail in the actual document. You can put it in an annexure at the end. And the reason you want to do that, if I'm giving legal services to Vodacom, as in our example, every time I say, Vodacom shall pay for the service of drafting a contract, reviewing a contract, drafting resolutions, and that's why you have a definition, to avoid all of that. So when you say services, you've defined it clearly to avoid doubt, and everybody knows what you're talking about. Now, the way to read a definition section is to look at the word used in the section. So for example, intellectual property, you will see it's bolded, you will see the I and the P are in capitals. What that tells you is anytime you see intellectual property and it is capitalized, they are referring to intellectual property as defined. Yeah. So if you have a question, for example, on you're reading the contract and it says there intellectual property and it's capitalized, and you're thinking, but would this include a computer program? You go back to the definition and you see, yep, they say any computer software is included as intellectual property. So that's how you read it. And the converse is also true. So if you see intellectual property in the agreement and it is not in capital letters, what that tells you is they are referring to intellectual property in the ordinary course, not as defined in the agreement. Yeah? So for example, if you have, we do have it here, you have a definition for business day. Says any day other than a Saturday, Sunday, or a public holiday. So if I then say, For me to cancel the contract with Vodacom, I need to give them 7 days notice. Which days am I talking about? No, I'm not. I said 7 days. And the only days that are defined are business days. So it means when I use days in the contract without capitalizing or making it business day, I'm talking about any ordinary calendar day. And it's not necessarily a business day. And when I talk about the business day, then I should, in that clause, say within 7 business days. In addition to definitions, most contracts have an interpretation clause. The interpretation clause tells you how to read and understand the contract. A good example here is most interpretation clauses, even this one has it. I think it is, I saw it. I can't see it now. But anyway, most interpretation clauses provide that whatever is in the contract, whenever there's a reference to a gender, it must be read and understood to include the other 2 genders. What that means, if the contract says, Ntombi shall render the services timeously, and it says he must comply with the following, I can't then turn around and say, but they said he, I'm not a he, so this actually is not referring to me, because what does the interpretation clause say? Any reference to one gender includes the other genders, right? The same thing with the interpretation clause. It will also tell you how, for example, to calculate days. So the interpretation clause will tell you, as a lawyer, this is important to us. And as you, there it is, if you look at 1.9, it says, where any number of days is prescribed in this agreement, same shall be reckoned exclusively of the first, inclusively of the last. Because we always have that question. If you say I must give you 3 days notice, do I count the first day or don't I? Do I count the next day as the first day? Because that makes a difference as to whether I'm complying or not. So there it tells you how to calculate the days, so that anytime there's a reference in the agreement to 7 days notice, you know you count the first day, but you don't count the last day. So that's how you interpret it. Okay, we're going to look now at some specific clauses. The specific clauses in the contract are really dependent on the nature of the contract. It depends, and the nature of the contract is determined by what it is intended to do, what it is intended to cover, who it is intended to protect. All right? And also, the specific clauses set out rights and obligations. Who's entitled to what? Who's required to do what? It answers the basic questions of the what, the who, the when, the how, and most importantly, the how much. Yep. So the first question, the what. What is this contract for? You see at number 3, at clause 3. In fact, 3.1, it says, NDI is appointed by Vodacom to provide legal services, right? When? The next clause, duration. It says, from the effective date until the completion of the project or the completion of the delivery of the services. So that tells you the term of the contract. So some contracts will say the term of the contract shall commence 1 January 2025 and terminate December 2027. So you know it's a 2-year contract, for an example. How? Or what? Or when? No, you are rendering services. And then they tell me how they want me to render those services. That you will look at the scope of services, and you'll also see the service provider obligation. That is where I now, as NDI, bind myself to render the services and to render them in accordance with these standards. I am an expert, I'll be skillful, I'll be diligent, I will deliver on time, and that's how I bind myself. The how and the how much. The how and the how much, again, is I've bound myself to say I'll do it on time. I will do it as an expert. I'll be diligent. The how much is how are they going to pay me for these services? I've already touched on this, and this is a big thing. You need to always be clear about what works for you. You may not be able to negotiate with Vodacom about their terms, but at the very least, once you've read the contract, you will know what you are in for. Versus being surprised, where maybe the first 2 months they will pay you within 30 days. And then month 3, you're waiting. And then they tell you, no, but our payment terms are 90 days. And then you actually go back to the contract and you realize that's what you signed up for and that's what you agreed to. So it tells you how you're going to be paid. It tells you when you are going to be paid. And one of the things that always gets snuck into these agreements are penalties. Because if you look at Clause 9, it just says fees and remuneration. So you assume that they're just talking about how they're going to pay me for the services, when, etc. And suddenly at 9.4, it says penalties. So now they're introducing penalties for late delivery of work, incomplete work, any gripe that they may have with the service, they're now introducing it. And they're saying, for example, they say the penalty is going to be a reduction by 5% of my fee for each day that I'm late, right? And you can see how that eats into my fees, my profits, my money. Now you will say, but how can they put penalties in this clause when the heading of the clause says fees and remuneration? Valid question. How do you figure it out? Back to the interpretation clause. Most interpretation clauses do say headings are only for ease of reference. So if what's in the body of the clause contradicts the heading of the clause, you ignore the heading and you focus on what's in the body of the clause. And that is why clauses like the interpretation clause are so important when you're reading the contract. Now we're going to look at some standard clauses. So this is what we as lawyers refer to as boilerplating. You will find them in each and every contract. That does not mean they are not important, because when an issue arises, these are some of the clauses that we always run back to. Termination, cancellation, and breach. Termination refers to a situation where the parties agree to terminate the contract. So in this clause, a termination clause will usually say you can terminate by giving 30 days written notice. So it means you give me notice, you calculate the 30 days. At the end of the 30 days, the contract is terminated because I gave notice. Cancellation, on the other hand, is a unilateral act. It is something that I, as a party to the agreement, make a decision to do, and I implement. It is for me. Usually, cancellation is related to a breach. Most contracts provide that in the event of a material breach of the contract, then after giving 7 days notice and giving the party an opportunity to rectify their breach, then you can cancel the contract and claim any damages that you suffer. What is a breach of a contract? A breach of a contract is when one of the parties is not complying with their obligations under the agreement. But remember, I said for breach, we're talking material breach. So material means it must be an important breach. What is an important breach to a contract? It is a breach of the clauses that go to the heart of the contract. So, for example, in a service level agreement like this, my provision of the services goes to the heart of the contract. So if I breach any of the obligations that I undertook in relation to the services, then Vodacom has a basis to say I've materially breached, because this whole contract exists for me to render them these services. Similarly, the payment terms of the contract are a material term. I'm not doing this out of charity and, philanthropy. I'm doing it to earn the fees. So if they fail to pay me as and when they've promised, again, a material breach of the contract, and I now have a basis to cancel. What you should watch for in these termination, cancellation, and breach clauses is A, the notices that are required to be given before you can terminate or cancel. You also need to be clear about the calculation of the days. All of these clauses have some period attached to it. Notice, give 30 days notice, give 14 business days notice before you can terminate. And you need to be cognizant of that. And some of them, especially in the case of breach, always provide that in as much as you've given them a notice that you want to cancel the contract because they have breached it, they have, during that notice period, an opportunity to rectify the breach. So if Vodacom was to issue me with a notice of breach to say you have failed to deliver the report you promised within the time you promised, during that 14-day notice period, I have an opportunity to kick myself in the butt, get into action, finish the report, and submit it. Then I'm compliant, and that way, Vodacom and I can speak again. I say, I have complied. Then the breach falls away, because I'm back in compliance with the agreement. Another standard clause is around confidentiality. So confidentiality is an undertaking that the parties to an agreement make to each other, in which I promise Vodacom that any information that they share with me, I will hold confidential, and I will treat it as if it's my own confidential information. Similarly, they undertake the same obligation. And both of us also undertake that we will make sure that our employees and anybody that works for us that comes into contact with this information will treat it also as confidential. This is important, as you can imagine, because especially in our business, and I think in most businesses, because in a contractual relationship, you share a lot of sensitive information to help the other party understand how your business works so they can deliver the service to you, right? To help the other party do the actual work. There is no way an attorney can give legal services without being privy to confidential information. I need to know what happened at every point. And as part of that, I am saying, you tell me, it stays between us. Of course, we also have legal professional privilege, but this is what this clause is meant to protect. I keep your information confidential, you keep my information confidential. We also, so you can tell that this is an old agreement because there isn't a reference to the POPI Act, which is the Protection of Personal Information Act. So the POPI Act is meant to protect our individual, as in our individual personal and private information from being shared willy-nilly. The POPI Act says if you give me your confidential information for the purpose of me rendering services to you, I cannot use that information for something else. Because if you remember, there was a time where you would get into a telephone contract with Telkom, right? And you sign and happy-go-lucky, and you think that's it. 3 days later, You're getting calls from My Way, from Outsurance, from all these people. Why? Because they have now sold your personal information to all these other companies so that they can approach you. And this act is meant to combat that, to say, if I give you my personal information for a specific purpose, you are only allowed to use it for that purpose and nothing else. Dispute resolution. So now it's been going well with Vodacom. It's been going great. But suddenly they start not giving me the information that I need to do the work that I need, right? It's not a material breach because I can still do the work, I just won't do it as well. I can do the work based on information in the public, I can do the work based on what little they've given me, but to do it properly, I feel I need more information. And we get into a fight about it. They're like, no, you have all you need. I'm like, no, but then if that's the case, I am going to have to limit my liability. I'm going to have to do this. I'm going to have to do that. And now it's a bond fight. The dispute resolution clause dictates how you resolve disputes that arise out of the contract between the parties. Most dispute resolution clauses will say, first, you need to sit down and talk as the parties and see if you can't come to an agreement. I've sat with the same person I've been fighting on email with, clearly it's not going anywhere. Then the dispute resolution clause says, refer to mediation, right? We refer to a mediator, the mediator hears both sides, the mediator says, this is my recommendation. The thing with mediation, as peaceful and as kumbaya and as beautiful as it is, mediation decisions are not binding on the parties unless the parties agree up front that whatever decision is given is going to be binding. So we didn't agree that the mediation decision will be binding. So the mediator gives their recommendation. I'm like, no, I don't agree. The contract says, okay, you can take it further. Then you can go for arbitration. Now, the arbitrator's decision in this clause, it will say, is final and binding. So we'll have another opportunity to resolve it, wherein we put our case before the arbitrator, listens to both sides, and he makes a decision, and both of us are bound by it. So the dispute resolution clause is meant to regulate disputes. A breach of the contract is not, for me, a dispute that can be resolved by dispute resolution. You follow the breach clause all the way, yeah? Warranties, indemnities, and limitation of liabilities. This is where we tend to sell our souls to the devil without even realizing that we've done so. A warranty works by saying, I give you, it's similar to a guarantee. I give you the guarantee that I am authorized to represent NDI, that you can believe what I tell you as a representative of the company, that I hold the necessary legal, regulatory, whatever it is I need to do the job that I've promised I can do for you. A warranty works in a service level agreement the same way as a warranty would work in a supply of goods agreement. Because remember, when you're supplying goods, most companies will have a warranty period where they say if it breaks within the first 7 days, you can give it back. It works the same. So I'm saying I warrant my services, that you can trust them, that you can rely on them, and that I know what I'm doing. An indemnity is where we get into trouble. An indemnity says, should you get into trouble, and you list what kind of trouble you're thinking about, should you get into trouble because of my actions or those of my employees, then I will indemnify you. I will hold you harmless, which means I take the responsibility to make you good, whatever loss you suffer because of my action. provided, of course, that it is within the realm of this agreement and the services that I'm providing pursuant to this agreement. A lot of big corporates expect and demand these indemnities. And you end up indemnifying them and binding yourself to pay special damages, consequential damages, so that, and special damages and consequential damages are not just limited to the actual financial damage that my actions would have caused Vodacom. They go further and they say, you know, Vodacom lost revenue because of you. Future revenue. Now they're doing projections, estimations, calculations to say how much my actions cost them in future revenue. And that's how we shoot ourselves in the foot when it comes to indemnities. So if there's anything that you look at first in a contract after the payment clause and making sure there are no penalties in there, it is these indemnities. What I always have in my contracts with my clients is a limitation of liability, wherein instead of giving an indemnity, because remember the indemnity is in favor of the client, it's in favor of the other party, it says, whatever happens, I got you. Limitation of liability says, I have given you the warranties that I'm good at what I do and I know what I'm doing, but if for any reason I get it wrong, my liability for any losses that you suffer because I gave you the wrong information is limited. And you say to what it is limited. My limitation of liability clause in my letters of engagement limits my liability to the fees that they have paid. And similarly, you need to understand why a Vodacom would demand that from you when you enter into an agreement with them.
I don't know if it is the right answer, but
there, all the way over there. Yes. Hello.
I'm not sure if my answer is right, but I would think that they go for the dispute resolution clause.
Okay.
Solely because there was an agreement in place, but obviously they haven't held up their end of the bargain, so there is a dispute over the payment. So obviously that dispute has to be resolved. So we go to dispute resolution clause.
Okay, that's one answer.
That's one answer. There's a gentleman here. You had an answer as well. He was, and then there's two behind you, but he was first. This gentleman, yeah. Hello.
Yeah. So you were asking us if they one thing they are right to do.
No.
No.
The question was, what do I do?
What do I do?
Oh, what do you do?
Yes. Yes. And 3 months later, they still haven't paid.
Oh, then obviously you go for the dispute.
Resolution?
Yeah.
Okay.
Yeah, that's what you do.
There were two others behind you, Sissy.
Well, I believe what I wanted to say is not what it is anymore, but essentially the law is a very specific endeavor. So what it said was they had an agreement, they didn't specify how long the agreement was for. We learned it was for 6 months, we learned it was for 3 months. So
And you're talking about here the time to make payment, right?
yes,
Okay.
yes. So there wasn't really a given time frame for them to make payments. So that's just you can dispute it whatsoever, but until we really know what the agreement was, there isn't much you can do about it in that situation.
Okay.
Wow, very important.
He's very adamant he has something to say. Just two more. Hello.
First of all, since the payment of the service ended, it's material term of the contract. What you can do is just cancel the contract because it's already 3 months, which has already passed. So you can no longer force Vodacom to make payments because it shows that they are not within you before.
So who must cancel? Who must cancel? Who must cancel? When you say cancel, what do you mean?
receive the payment.
Right. So yeah.
NDI.
This is applicable.
Yeah. Yeah. Okay. Last.
Yes.
Right. Some of the con.
Okay.
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 Last gentleman in the front.
Right. I think if in the beginning, I think I was trying to kind of remind them in everything. So if I send them a notice, remind them, and they still not pay, I think I can, as a last resort, I can just go for legal action. But it will also depend on what was on the contract.
You can go for one side.
For
Illegal action.
Yeah, so what's the legal action? That's the question. What is the legal action? What do you do?
it will depend on what was in our contract.
Yeah.
If it was specified in the contract, what we need to do if there's a late payment. Because maybe they don't screen it on purpose, maybe they just wait for any unforeseen circumstances they couldn't pay. So it will depend on what was in our contract.
Yeah.
Great stuff.
Thank you. The answer. The lady at the back headed the closest, and you were on the same path. But the first step is to check, what do my payment terms say? If my payment terms say Vodacom can pay within 120 days, guess what? 3 months ain't it. I still have to wait. They are not in breach. If my payment terms within 30 days, say within 30 days of receipt of the invoice, then they are in breach. And remember what I said, I am not in business for philanthropy. So the payment of my fee is a material term of the contract. So because it's a material term of the contract, I can skip past dispute resolution and go straight to termination, cancellation, and breach. And what I will see in there is that it will say, you can cancel the contract in the event of a material breach, but you need to give written notice of 7 business days, which means then I can't just say I've canceled. I send them a notice that says, I'm hereby canceling within 7 days because you have not done X, Y, Z. And what I also said about the breach clause is it generally allows them within that 7-day notice period to rectify the breach. So if they suddenly pay me, they are no longer in breach and we're back in the contract. Yeah? And that's the answer.